Everyone, I'm excited to be talking to you today about King vs. Innovation Books 1992. I hope you've all had a good week. I'm feeling a little bit under the weather and I have an issue going on with my eye, so there's that. But I'm going to start with a brief overview of this case, and then I'm going to go over the facts, the issue at bar, the decision of the court, the rule of law, and then finally the disposition. So, a brief overview of this case. The plaintiff is Stephen King, and he sued a production company and distribution company after they used his name and credit in a movie based on a short story that he wrote. And the district court granted a preliminary injunction on his behalf, and the Court of Appeals affirmed this decision. Oh my goodness. Okay. So the facts of the case. The plaintiff is Stephen King, a horror movie producer, extremely famous, and the defendant is Allied, a British motion picture distribution company, and New Line Cinema Corporation, an American motion picture distribution company. Stephen King wrote this short story entitled The Lawnmower Man, the short story, in 1970. And this short story was essentially about a man that had a boy come mow his yard, and one day he mowed over a cat, and so the man couldn't bear to have this kid come back for a while. His grass grew long, and he finally was able to get another guy to mow the lawn, and this guy ended up having telepathic powers and was able to send the lawnmower to chop up the man. Kind of strange, but it was interesting to read about. And so Stephen King assigned the motion picture and television rights to Great Fantastic Picture Corporation, and they transferred these rights to Allied. And Allied assigned the distribution rights to New Line Cinema Corporation. Then in February 1991, the defendants began to market the motion picture as Stephen King's The Lawnmower Man and claimed it was based upon a short story by King. Then in October 1991, King ordered his attorney to tell the defendants he objected to the use of his possessory and based upon credit. And on March 3rd, 1992, not May, he was able to view the motion picture days before it was released, and then he filed suit against the defendants in the United States District Court for the Southern District of New York. Here is a picture of the Lawnmower Man, and if you can see, it's very small in the middle below the eye, right above the Lawnmower Man. It says Stephen King's. The issue at bar, Stephen King sued for damages and filed for a preliminary injunction because he claimed that there were unauthorized uses of possessory and based upon credits, and that he also claimed there was a violation of the Lanham Act Section 43A because the credits were false and misleading, and he did not authorize the Lawnmower Man to be filmed and based upon his short story. And so possessory credits are the use of a film credit which gives primary artistic recognition to a single person, usually but not always the film's director. And obviously, Stephen was not the film's director. He was not even involved in the screenplay. The decision of the district court granted preliminary injunction against the defendant's use of credits, and the Court of Appeals affirmed the district court's decision for this possessory credit. And a preliminary injunction is an injunction entered by a court prior to a final determination of the merits of a legal case in order to restrain a party from going ahead with a course of conduct until the case has been decided. The rule of law in this case, so the district court would affirm the preliminary injunction on possessory credit. So essentially they said that the defendant had used possessory credit unauthorized based upon credit and ultimately caused irreparable harm to the plaintiff. And they said that there was substantial differences in the film and in the book, so they couldn't equivalate that it was based upon the film was essentially based upon the book. And the Court of Appeals said that the district court used the wrong standard of review for based upon credit, and that they were actually substantially similar. The film compared to the book were substantially similar, and the film used the core of the short story, which the district court denied. The disposition of this case, the Court of Appeals for the Second Circuit affirmed the injunction against the possessory credit in King's name. And so ultimately the Court of Appeals affirmed the injunction against the possessory credit and basically denied the based upon credit and said that the possessory credit, yes, they used Stephen King's name unauthorized, and they said Stephen King's The Land Mower Man, and this was not an okay use, but they also used based upon, and they said that this was okay because he used the fundamental core and they were substantially similar enough, so they could say that it was based upon Stephen King's work. And so that is King and Verse Innovation Books, 1992. What do you think of the Court of Appeals decision of affirming the possessory credit but not the based upon? Do you think this was a good decision? Do you think they should have affirmed both like the district court? Or do you think they made a good decision in saying that the district court erred and saying that the based upon credit was granted to get damages for King? And so let me know what you think, and I'm excited to hear about your cases as well. Have a great weekend.